I'm Polk Wagner. This is my colleague Cynthia Dahl, and welcome to our springtime review of patent cases before the Supreme Court for the October 2016 term. We have two cases that that we sort of advertised that we were going to talk about. There's a third, LifeTech versus Promega, which also has come out in the last couple of months that we can also talk about. We have some slides about that as well. I think the plan here is we're going to each go through the cases and talk a little bit about it, and then sort of have plenty of time at the end for Q&A or whatever other discussion you guys want to have. So unless anybody has any questions, we'll go ahead and get started on this. So I think the first one, so these are the three, and we'll start with SCA.
Diapers first.
Sure.
Okay. So I drew the short straw. I get the diapers rather than the cell phone. A little less sexy, but anyway. It's sort of an interesting case of SCA Hygiene Products versus First Quality Baby Products. And actually, one of the professors at Penn Law helped on this case. So it was interesting to hear him moot it actually a week before the argument. So that was kind of a fun insider part of that. Okay. So I'm going to talk a little bit about what the background facts were. Then we're going to talk about what the statutes are that are at play. And then we'll talk about what happened in the Federal Circuit, and then, of course, what happened in the ruling. And then I'll turn it over to Polk to give you sort of, to tee up the other two cases, and then we'll have a discussion. Okay, so background facts. Both of these companies create adult diapers. And SCA first wrote to First Quality way back in 2003 and said, put them on notice that they were infringing SCA's patents. First Quality wrote back and said, actually, you're infringing our patent. We have a prior patent, and you're the bad guys. So SCA didn't say anything again to First Quality, but went to the USPTO and asked for a re-exam, timely re-exam in July of 2004. It took about 3 years to get that re-exam back, but when it came back, good news for SCA, confirmed the validity of the patent. Then, for a variety of reasons, SCA waits until August of 2010, and they file a suit against First Quality for patent infringement. Meanwhile, of course, between 2003 and 2010, First Quality has invested a lot of money in their adult diaper product. So First Quality's answer back to SCA was, no, claim of laches. You can't wait that long. We've been damaged, and SCA should not get those back damages for infringement. Okay, those are the facts. On the district court level, the district court ruled for First Quality, both on equitable estoppel and on laches. It went up on appeal to the Federal Circuit, and the Federal Circuit decided that a lot of things. They said a lot of things. First of all, yes, laches. SCA can't allege the patent infringement. The damages are subject to laches. And then they said laches, not only that, laches is codified in Section 282 of the Patent Act. We'll look at that in a second. And never mind, it can coexist with a separate time limitation defense that's in 286. And they said, no problem here, that laches applies both to law and equity. So slam to SCA. Then actually what had been happening in the meantime, after the district court, before the Federal Circuit, the Supreme Court looked at a case called Petrella. And in Petrella, in the copyright realm, it said that a defendant can't invoke laches to bar a damages claim, specifically because in the Copyright Act, it says that there's a 3-year statute of limitations. So laches doesn't apply in the copyright realm when you have a statute of limitations specifically in the statute. Then they had this curious footnote, and they said, okay, so the Federal Circuit had this other case, Ackerman, and in Ackerman, the Federal Circuit has said before that in the patent realm, laches could coexist with a statute of limitation, or actually a look back. And the court said, quote, it had not had occasion yet to review the Federal Circuit's position. So here's the occasion. And the question that was presented is this: whether and to what extent the defense of laches can bar a claim for patent infringement brought within the Patent Act's 6-year statutory limitations period. So what are the two statutes that we're looking at, or two parts of the statutes? We're looking at 282 and 286. In 282, it lays out some defenses to patent infringement. It never actually uses the word laches, but it says that it's a defense when there is an absence of liability for infringement or unenforceability. And First Quality made a lot of hay about this unenforceability word, and they said for decades and decades, unenforceability has included laches. So it doesn't matter that laches isn't actually in there, unenforceability equals laches. So they said in 282, it includes specifically this laches defense. And then in 286, we've got basically a statute of limitations. It says that you can't recover for any damages that exceed 6 years, a 6-year period before you filed the case. This is a little different than a statute of limitations. There was a lot said about the case in the briefing, but the Supreme Court basically said no, this is a statute of limitations. Okay, so what do they hold? They said basically vacated in part, sent back down. Laches is not available, just like we said in Petrella, in a patent scenario, because we specifically have carved out the statute of limitations, and that was basically what Congress wanted to do to limit damages for patent infringement. Okay, so specifically, what did the case say? A couple of interesting things. First of all, it said specifically that this look back is totally equivalent to a statute of limitations. Congress has spoken, and this is the way that they have limited that defense. It said laches is only supposed to be a gap-filling doctrine, and there's no gap to fill here because we have a statute of limitations, and so don't ask for laches as well. And it said, by the way, there's not a single other federal statute that has both. So Congress couldn't have meant to put both in, so don't tell us that laches is automatically put in under unenforceability. That doesn't fly. Breyer was the only one to dissent. He said that the gap that was left by this 286 basically is going to, public policy-wise, is going to incentivize the wrong thing. Patent holders are going to wait a very long time before they sue. They're going to figure out whether it's worth their while. And that is a gap enough that we should allow laches to basically punish those very egregious offenders. He spoke more than anyone else at the argument, and he specifically distinguished from Petrella. So a couple of takeaways. If Petrella was a resounding statement at 6-3, SCA was even more so at 7-1. And they even start off, Alito wrote the opinion, and they start off basically saying, we just tried this case with Petrella. So you knew which way it was going to go from like the very first line. So it was almost unanimous. What I thought was kind of interesting about this is that we've seen a lot of patent cases recently at the Supreme Court, and this is one of the only ones that has gone towards the patent holder, arguably. A lot of the other cases have gone the other way. However, it is consistent with the Supreme Court's recent resistance to the Federal Circuit's what they call patent exceptionalism, basically making extra special care for patent cases. And so in that way, it was consistent with what they've done before. Some other interesting takeaways, I thought. This Laches defense I'd read was actually often pled, but is not actually usually allowed. It doesn't usually work. So why are we caring that the Laches defense is now off the table? Because a lot of accused patent infringers were using the Laches defense as a club at settlement discussions, and now that's completely off the table. It's not impossible to kick out a case where the plaintiff has waited a very, very long time to bring the case to court. You can do this still through, an accused infringer can stop the case through equitable estoppel if there's been sort of deceptive practices. And so you've still got equitable estoppel, but there may be some more emphasis put on equitable estoppel now to stop that truly deceptive behavior. People were worried that if the Supreme Court ruled the other way, that plaintiffs would have to file suit before they were ready. And of course, now they can wait because there's no Laches Defense, and they can file suit when they actually are ready. However, it does require everyone to keep some careful records longer. So a couple of public policy points to point out. Maybe we can get into this in the discussion. People were worried, Breyer's worried in the dissent, are more parties going to wait to file suit, and are we going to get a floodgate of trolls? Ginsburg said, so what? She wasn't actually worried about this at all. She said people should have the opportunity to wait as long as they need to figure out whether or not they should be bringing this suit. So she was not worried about this public policy question. Question whether patent cases are different from copyright cases for two reasons. First of all, perhaps the money is higher. There's more investment put into the product, into the company than in a copyright situation. So maybe the risk is higher if you take Laches out as a defense. There's also the concept of innocent infringement with patents. You could, it didn't happen in this case, but you could see a case where someone invests a lot of money, doesn't realize that they have actually filed, that there's a patent out there. The patent holder waits an awful long time and then sort of submerges or emerges, like a submarine patent emerges, and brings the suit. And so perhaps patent cases are different from copyright cases, and there should have been more of a distinction between this case and Petrella. Some people are writing about how this is going to benefit universities, all sorts of NPEs, but specifically people look at the less maligned white hat university NPEs. They talk about them having limited staff, limited money, and at this point they can evaluate when they want to bring a case. So this may help some universities and also help people that have held on to their patents for a while. Although those older patents can't really be used for a long time to gain damages going forward, now without that Laches defense, they can be monetized against more damages that go back further. Query whether this will lead to higher patent awards, we don't know. Query whether this is going to actually stifle innovation, we don't know. And I did want to talk about this too. When we're talking about patent exceptionalism, we just had another case that was argued last Monday before the Supreme Court called TC Heartland, and I wonder if this is the way that the Supreme Court is thinking. I don't know if I would have wanted to have argued that case right after they came out with this one, because it's sort of a hard road to hoe, when you're talking about treating patent cases differently from other cases.
Excellent. All right, thanks. All right, so I'm going to talk about these two cases, but I'll talk first about Samsung versus Apple. So the facts here, as you are probably aware, have to do with a decades-long infringement series of infringement actions between Apple, primarily as the plaintiff, although there have been a bunch of cross-claims, versus Samsung litigating about smartphones, basically the iPhone, right? So what has finally sort of burbled up to the top, to the Supreme Court, is a question about design patents. They had a bunch of other patents involved for many years, but what really happened was Samsung was found to infringe some of its early Galaxy products were found to infringe design patents related to the iPhone. In particular, some of the user interface layout, the rounded rectangles, the overall rounded rectangle of the screen, those design elements were found to have been infringed by Samsung in its production and distribution of some of its phones as well. Samsung was found guilty on those. The Apple patents were found to be valid, and damages were assessed in the neighborhood of $400 million. Right? So now this goes up to the Supreme Court, and Samsung's argument here, and the question presented is this: when a design patent is applied to only a component of a product, should an award of the infringer's profits be limited to those profits attributable to the component? All right, so the question here is the $400 million an appropriate amount for Samsung to be liable for its infringement of the design patents? And the reason Samsung says they should not be liable for $400 million is because merely one aspect of the iPhone, or a couple, as it turns out, but really let's think about it in terms of one aspect, the rounded rectangle, right, the sort of unique shape of the iPhone, clearly a design element, but also one particular component of a very large, multi-component, high-technology device that has a lot of innovations in it. And Samsung says, all right, we're willing, totally willing to pay the damages that we should pay for infringing that particular design element, but that isn't everything, right? That's not all the profits that we made on our phones over the years that we were selling them. And that's the issue. Why is that an issue? Well, because the statute for design patent infringement actually has a special rule, right? In typical utility patent infringement, there would be some sort of assessment about either a reasonable royalty or the lost profits available to Apple. But here, there's a special rule, and the special rule is if you have infringed, if you sell or expose for sale any article of manufacture to which design or colorable imitation of the design has been applied, shall be liable to the owner to the extent of his total profit, but not less than $250, right? So this is a special rule for design patents, right? This was put into place in the late 1800s in response to a Supreme Court ruling that said that design patents got the same treatment as regular patents, right? And saying that that you would try and figure out what the actual contribution of the design was to the overall profits, and you got that as your damages. So the designers lobbied to Congress, and they got the law changed, and they got the law changed to this, said total profit, right? So at one level, this is easy, right? As Justice Sotomayor said in the sort of initial part of the case, if the design element, if the product you're selling is a plate that has a unique design, like a dinner plate or something, then the design and the product are the same thing, and you really don't have much of a problem. If you infringe it, it's your total profit, end of story. However, if it is, as she suggested, a component of for example, a oven, right? There's a lot of components, right? And the design of one element of the oven is clearly not the entire oven and clearly not worth the entire oven. So that means that becomes a much more difficult question. And here it raises that second issue, right? So what happened at the district court and the Federal Circuit is they did the analysis, statutory construction analysis, policy analysis, and they said the relevant article of manufacture, the key language here in red, is the phone, is the entire phone, because that's what's sold, right? Nobody's selling just the steel rectangle or the glass rectangle. Nobody's selling just the tiled software, right? If you want access to the design, you have to buy the phone, right? So therefore, that is the article of manufacture that's being sold, and therefore that's where we attribute the damages, and therefore it says total profits associated with that, that's it, right? So thus, Samsung is liable for the total profits associated with the infringing product is sold. Samsung appeals, right? Goes to the Supreme Court and says this is wrong, this interpretation of article manufacture is incorrect. So, the Supreme Court takes a look, does a statutory construction analysis, right? And decides that indeed the Federal Circuit was wrong about this, right? And that the term article of manufacture encompasses both the entire product and a component of the product, right? They say that in the case of the dinner plate, it's the entire product. In the case of the oven or the iPhone, it's something not the entire product. It's the component of the product, right? And so they didn't choose between either the total product or one component. They said it could encompass both, right? And so that means what the Federal Circuit and the district courts had said before was reversed. Now, the interesting or perhaps disappointing, depending on your view, in my view, disappointing aspect, here's the actual holding. The term is broad enough to encompass both a product sold to a consumer as well as a component of the product. A component of product, no less than the product itself, is a thing made by hand or machine. That's what they define article of manufacture to be, a thing made by hand or machine. That a component may be integrated into a larger product, in other words, does not put it outside the category of articles of manufacture. They said irrespective of whether it's separately sold or not, doesn't matter. However, then what they do is they go on and say, the parties then ask us, the next obvious question is, all right, so how much is Samsung liable for, right? Are they liable for 10%? 20% of their profits, 2% of their profits? They suggested $12 a phone, right? Very, very small. Would have been less than $10 million was their proposal, right? And so that's the next question. And the Supreme Court declines to answer that question, right? It says the parties ask us to go further and resolve whether the relevant article manufacturer is the phone or a particular component. However, doing so would require us to set out a test for identifying the relevant article manufacturer at the first step of 289 and to parse the record to apply that test. In this case, we decline to lay out a test for the first step. In the absence of adequate briefing by the parties, doing so is not necessary to resolve the question presented, and the Federal Circuit may address any remaining questions on remand. This is the ultimate of all punts, right? They just simply avoid the issue completely that would be required to actually decide this case or, frankly, any other case at all, right? It's hard to overstate how much they just simply say, we're just not going to tell you. And this is, they say they were going to, then the ellipsis here, they state that the parties didn't fully brief it, which is actually not true. The parties did brief it, and the parties in the United States in their briefs, and all of the amici had their own versions of the tests, right? So it's not like this was in any way a surprise to anybody. Now, they didn't argue about it at oral argument because the court was interested primarily in defining what article manufacturer actually means, and so they weren't sort of talking about the test. But at issue was, if you don't say that article manufacturer is the sold product, then that means you have to have some sort of messy test, right? You have to have some sort of way to distinguish between when it's just the product being sold versus some component of that product. How do you know when it is? How do you know what we mean by the component? That is not easy, and that was one of the primary reasons. In fact, that was the reason that the Federal Circuit said that it needed to stay with article of manufacture, because there was no principled reason, no good test that they could discern that would allow them to parse the product any more narrowly that wouldn't end up just being completely ad hoc in every case. So it is disappointing, I think, to say the least, that the Supreme Court decided that it wasn't going to offer this up. Now, potentially defensible. They don't like to rule on questions that haven't been fully litigated. As Cindy and I were talking right before this, what happens, as you might expect, is it goes back to the Federal Circuit, and the Federal Circuit says they read the case. And what would you do if you're the Federal Circuit and the Supreme Court dumped this on you and said, well, what you said before was wrong, but we're not going to tell you why, and we're not going to tell you what the actual answer might be, right? Like any good appellate court, you're not going to answer the question either. You're going to kick it back to the district court, right? So that's exactly what they did, is they remanded it back to the district court. Poor Lucy Coe in the Northern District of California, who is now stuck trying to come out with a test that the Supreme Court admits they have no idea what to do, right? And this is going to be an interesting question. What happens now? So in the opinion, the Supreme Court mentioned that the Department of Justice, in their amicus briefs at the court, had suggested a test, and that maybe, and they didn't say anything about it, but by sort of inference, that suggests the Supreme Court is at least sort of nodding and winking at that possible test. However, this test is, those of you who've spent some time studying various problematic aspects of the law will know that this test, which is otherwise known as the totality of the circumstances test, right, has precisely zero content to it. It basically is telling courts to come up with a bunch of different factors, and that each factors are going to weigh quite differently depending on any individual case, right? And so what the Department of Justice is saying is what an article of manufacture means depends on the individual circumstances and can't be sort of preordained, right? And we can talk about this maybe a little more in the Q&A, but this is going to be a really difficult test to apply in any particular circumstance, and basically impossible. By definition, totality of the circumstances means that you can't predict the outcome before you litigate, right? So people who like nice, clear rules, or even the ability to give advice to clients or anything that lawyers might want to do, are not going to be very happy with totality of the circumstances, but that's what we have. So what we've got now in this is we've now got this area of design patent damages law, which has been completely upended because we don't know now how to compute, right? We just don't know how to compute damages anymore. Is it the entire product? Is it not the entire product? Even, products that seem simple like, this water bottle, right? So there's a design patent, I'm sure, associated with this water bottle. So what is the component, right? Is it the entire bottle? Is it the bottle as shipped to the consumer? Is it some other piece? And because of that, we're never going to know until we get through what appears to be probably a long process of Apple versus Samsung at the district court level, then back to the federal circuit, maybe back to the Supreme Court, although maybe not, but certainly back to the federal circuit. So a long time before we sort of sort through what this means. What does this mean for design patent law? Well, first, the uncertainty, right? So we're going to have a fair amount of uncertainty for a long time. The second thing that it does do is it's going to decrease the power of design patents. And I think that's probably why the court came out the way that it did. There's been a lot of concern in industry that design patents, which for years and years was regarded as sort of this sleepy backwater, nobody really cares about design patents, right? They're sort of these weird 15-year patents that nobody ever used, all of a sudden, in the last 10 years or so, have taken on a huge amount of importance. A couple reasons. One, Apple uses design patents a ton, right? They figured out that they could get a lot of protection over things that they consider innovative, like shapes, design, software elements, that are otherwise pretty tough to find a way to protect in intellectual property rights. The design patents were going to work well for them, and so they've been using them, right? And second, there have been a series of cases at the Federal Circuit that have, on balance, expanded, and sometimes expanded quite dramatically, the scope of infringement of design patents, so that now design patents, which were thought to be a very narrow, like basically a picture, and if you matched the picture it was infringing, if not, you didn't get anything. Now they've gotten to be a much bigger scope of infringement, gives them a lot more power in the marketplace. So what seems to have clearly happened here is a dialing back of the power of design patents, because if you can't get total profits, then you're going to get something much less. And frankly, if you can prove in court that it only costs, that the allocated cost or the allocated benefit of that rounded rectangle is 0.5% of the total product, then it's barely going to be worth having the design patent at all. Right? And again, we don't know whether that's the case, and we certainly don't know whether that's going to be the case in any particular issue, but this has the potential of putting design patents back into sort of the backwater that everybody always thought they were, which might be good or might be bad, but it certainly has major implications for particularly companies like Apple that are doing this combination of technology and design. All right. So let's talk about Life Technologies versus Promega briefly. So the facts here is that this is a genetic testing kit, right? This is among the a boom area is to supply genetic testing kits. This is a genetic testing kit where almost all of the components are made and assembled overseas. However, one particular component, is made here in the United States and then shipped to the United Kingdom, packaged together with the rest of the kit, and then sold worldwide. Right? So you might ask yourself, why is this a patent issue at all? Well, it's a patent issue because 271F in the U.S. Code, in Title 35 of the U.S. Code, allows for an infringing act to be attributed to the United States if you are supplying some or all of the substantial components of the product in the United States. Why would Congress do that? Well, there was a well-known case in the 70s called Deep South where it was clear that somebody was trying to avoid the patent infringement liability by merely making products of a patented device, shipping it overseas, reassembling it, and then shipping it worldwide, thereby avoiding patent infringement, because at no point when it touched the United States was this anything other than a collection of individual items which are not patented. Right? So Congress, seeing that, said, oh, well, here's a loophole in the patent law, we got to fix it. Right? So they changed the law to say this: whoever without authority supplies or causes to be supplied in or from the United States all or a substantial portion of the components of a patented invention where such components are uncombined in such manners to induce the combination outside the United States in manner of the infringement patent if it occurred in the U.S. is liable as infringer. Right? So that basically says, look, if you're doing this, if you are taking all the components, shipping them overseas, putting them together, that's infringement. Right? That's infringement in the United States. Now, the question is, does 271F1 apply when you're not making all the components in the United States? You're making one component in the United States, one single component in the United States, rest are made overseas. Does it apply if that one single component is, as the evidence showed here, potentially the most important or most critical part of the entire invention? Right? So that's the question. Does that apply? Right? So this is how this played out here. One component, and then they ship the kits everywhere. So the Federal Circuit says, yes, that Congress said all or a substantial portion of the components of the invention, it could be a single component as long as that single component was, according to the statute, a substantial portion of the invention. Right? All right. So what essentially the Federal Circuit says is this is a qualitative analysis, right? What do we mean? Is it a big component, big part of the invention, small part of the invention? And if it's a big part of the invention, even if it's just one piece of the invention, one component of the invention, it's liable. It can be infringement. However, the Supreme Court says, well, we're reading the statute, and it's very clear that this is merely a quantitative analysis, right? Because of the plural of components, right? And they say that because of that, it cannot, as a matter of law, be a single component. End of story, right? So they say, in this case, it does not meet 271F1, and therefore, and then, as the Supreme Court likes to do, it says we do not define what it actually means to be how close to all a substantial portion it must be. We hold that one component does not constitute all or a substantial portion of a multi-component invention under 271F1. This is all that's required to resolve the question presented, right? The fallback of the court that has no idea what it's doing, right? Because the problem is, right, if you're not going to tell us what you mean by all or a substantial portion, but you say it's a quantitative analysis, you've just now engendered enormous amounts of unpredictability. Does it have to be 80% of the component, 8 out of 10? What if there's 3 components? Is 2 a substantial amount? Is 1 a substantial amount? This is a disaster, right? Because nobody, and it's purely quantitative. You're not allowed to ask, is it an important component anymore? Right? Because they were like, this is pure quantitative analysis. So now we have no idea what all or a substantial portion means, right? Whether it means a majority, less than majority, or whatever. All we know is, at this point, that 1 It's not enough, right? One single one is not enough. What does this mean for the future? Don't know, right? We are back to the drawing board, I think, on this. It's interesting to me that both of these last two cases I talked about are purely issues of statutory construction, where the Supreme Court just really doesn't talk about patent policy at all. I mean, we're very used to the court, and I think even in the SCA case, right, they at least talk a little bit about, or at least Breyer does, right, about the sort of the bigger issues of patent law. And in this term, we've seen them do this in the patent cases where they're really just, it's just a pure statutory construction issue. They're just not really talking very much about patent policy, innovation policy, the bigger pictures at all. Some of it's because these cases are frankly small, right? I mean, these are not many cases that arise under these particular provisions. Some of it is, I think they are reluctant to make sort of grand pronouncements, but it does make you wonder why they take these cases at all, because typically the Supreme Court doesn't like to take pure issues of statutory construction that are really bound by the particular cases at hand, but in these cases they have. So that's the three cases we have for you today, and Cindy and I are here and happy to chat more about that and love to hear your thoughts and ideas.
We have until 6:15, right?
We have, yeah, at least till then. I mean, we can end whenever we want to step outside, but yeah. All right. Any thoughts? Yeah.
Some questions about the Samsung versus Apple case.
Yeah.
So that case dealt just with the Galaxy 4, was it? Or
Yeah, long time ago. Original iPhone design patents and the Galaxy 4.
And they never brought that case as to further models because they're all continuing.
Oh, no, they have brought the cases,
Okay.
right? But the cases are at lower levels and have not. Right. I mean, one suspects that if Apple gets, you know, the answer it wants here, then its design patents, which have been held to be valid repeatedly, are going to be a pretty important stick for them to use if they want to against a variety of other possible manufacturers. And obviously, if they don't get that, then they're back to, you know, where they are now.
Can I
Sure.
ask a question on that? So do you think the damage is already done because of the Supreme Court decision that even if Apple ends up, if they figure out that the article of manufacture in this particular case, you know, if they go Apple's way, do you think that the damage is already done by the Supreme Court, that we've already got that insecurity and instability injected into the system?
Yeah, almost certainly, right? Because I think we're just not, you know, if there's anything, well, some of it might depend on the rule that they ultimately come up with after a bunch of litigation, right? But certainly if they adopt anything like what the DOJ wants, which is going to be sort of this major multi-factor, you know, throw everything into the pot and stir it sort of test, then that means you can't make any accurate prediction about what the damages in the individual case will be, which means your licensing conversations go very differently, right? But if Apple had won this case and gotten the answer that it's the total profits, that gives them a lot of leverage in litigation.
There's a question in the back.
Did Samsung try to argue that when it's based the design patents that Apple got had dotted lines to show that it wasn't the whole?
Yeah.
And where did that go?
Well, so I think that had been raised many times, and I'm sure it's going to reemerge, right? So when you do a design patent, so the question is, when you draw up a design patent, you file a design patent, you're filing essentially a drawing, right? A drawing of what your ornamental design is. That drawing has solid lines and dashed lines or shaded lines, right? The shaded or dashed areas of your drawing are, by law, not part of your design, but they're there to provide the context in which your design fits, right? So the question is, which I think is a good argument, is whether or not we can use that as sort of the measuring stick between what's the article of manufacture and what is not the article of manufacture. Now, the downside of that is that has to do with the boundaries of the design, right? But the statute actually says something different than the design, which is applies the patented design. So clearly the shaded stuff is not the patented design, but if you apply it to an article of manufacture, which is by definition here not the same thing as the patented design, then you get the money on the article of manufacture. So that's why that was never, it wasn't adopted below. I think you're going to see a reemergence of that among a bunch of other possibilities of how to draw these lines. But I would say that would be the narrowest way to slice this up, right? And that would, in fact, mean that literally only the glass cover plate would be the article of manufacture in this case. Sure. Right, and particularly back in the late 1800s when they drafted this distinction between machines and article of manufacture meant a lot more than what it does to us now. So I think that's, it's a good argument, and I think, like I said, it's going to be something that we're certainly going to see reemerge. That's not, the DOJ didn't want to go that way either. They just wanted the judge to take everything into account, right? Market position, how you sold it, what the design scope was, how the design was, how the advertising went about the design, all of that sort of thrown into it to determine what the relevant article manufacture is. Sure. Sure.
Agreed, and I'm a little confused about it as well, actually. The defendant, First Quality, raised a lot of these points and basically said that, first of all, a statute of limitations looks forward. This looks back. They also said that, what else did they say? That was their basic argument. They also had sort of a backup argument, and then the court actually devoted like 2 paragraphs to this and basically dismissed it and said, this is not how a statute of limitations works. Basically, in real life, when we're talking about a statute of limitations, it's not about when you can bring a claim, it's when you do bring a claim, and that the claim, the statute of limitations starts when the claim accrues. And I agree with you. I didn't really think that it was a good answer. They declared victory in about 2 paragraphs and then just sort of moved on. But I think that there are distinctions between the two.
Yeah, I agree with you. I would have, it was pretty clear how they were going to rule on this because of the footnote that they dropped in Petrella. But I think they just didn't spend enough time thinking about it. I mean, what's in the Patent Act is a pretty unique sort of look-back provision. That's, unique as far as we can figure out in most areas of federal law. And it seems like, from what we can tell, that Congress was pretty intentional in putting that in there to allow patentees to choose the time and of when they wanted to bring their infringement case. And of course, there is an effective statute of limitations on all patent cases, which is that the patent expires at a certain time, right? So, I think Congress was well aware of that and set this system up so that you could wait and sue when you thought you were going to get enough money to sue, but of course not too late, because eventually your patent just plain runs out. Yeah. I mean, there's still going to be, and I think Cindy's slide had this, be equitable estoppel considerations, right? So if you do things like suggest to people that you're not going to file a lawsuit or stuff like that, those can trigger. So it's probably not accurate to say that there's no limits on what you can do. But I think if you want to sit and wait for the right time, absent doing something that would trigger an equitable estoppel, then you seem pretty you can do it.
And that was, Ginsburg specifically brought that up and said, I hear you, Breyer, but people should be able to decide to sue when they want to sue. And Congress has spoken. There was a big emphasis here about court versus Congress. They went out of their way a couple of times to say, Congress has spoken, it is not for us to question. And if they want to change this, they can change this. And bear in mind, this was this year, right, when we're talking about a Congress that is not getting much done. So, but that's what they said.
They say that unless they want to decide what Congress already said, right? So it just depends. I mean, it's a rhetorical technique that they use when it benefits them. No, it was required to make the kit operate, and the kit was assembled. I don't know whether it was assembled in the sense of being mixed, but the kit would not operate without this particular component. So it was required, and they had testimony that I guess was unchallenged that it was the major or the most active or the most important component of the overall testing kit. The other components were off-the-shelf, rather generic components that they could build anywhere. The thrust of the claim was the real innovation was in this particular component that was made in the U.S. and then shipped overseas to their subsidiary in Britain, specifically to avoid the patent infringement issue. Well, so it doesn't answer anything. I mean, the thing about this case is they don't answer the question in any way other than to say that it has to be more than one, and to say that it's a quantitative only, not qualitative analysis, right? Because what the Federal Circuit says is it's unlikely to be one, but it could be one if that one component was the most important or most critical component, right? And the Supreme Court said that's just the wrong analysis, that it is a quantitative analysis that means more than one, how many we decline to tell you. So it's full employment for patent lawyers, so Cindy and I are happy about that because we're in the patent lawyer manufacturing business, so.
I wonder what that's going to do to manufacture here, if people are going to sort of parse what they do and how they do it in the United States based on this.
Yeah, it's unclear. You know, there's 271F2, which is, I didn't put on the board, but which might be read to be a little broader, where you can capture at least some of the more egregious behaviors. But again, there's so much uncertainty, it's not clear that this provides help to either side. Like if you want to manufacture outside the U.S., you don't know if you're safe under this, right? Because it could be, I mean, you know you're safe if you're only making one component, I guess.
Or
for now.
Or if you take all your manufacturing out of the U.S.
Or you take it all.
Because who wants to chance it?
Right. Or you take it all.
You just wonder.
All right, anything else? Comments, questions? All right, so thank you so much for being here. We are hoping, of course, to continue to do these sorts of presentations at CTIC. Anytime there's an important either case or news issue, look for emails from us announcing something like this. We like them to be sort of easy and informal and allow us to talk with anyone who wants to about what's going on in the world of intellectual property. So thanks so much for coming. There's a small reception right outside. So, all right.
Great.
Perfect. So thanks, everybody.
Thank you.
All right, good work. Thank you.